Hello and welcome to Holland Estates. You're listening to episode number 606. I'm Stuart Clark.
And I'm Jennifer Philpott.
Hello, Jennifer. How's it going?
I'm well, Stuart. How are you?
I'm doing well. This is our first podcast together, so
Yes.
glad to have you here. Welcome aboard.
Thank you. I'm glad to be here. It's an interesting discussion that we have today.
Yeah, so let's kind of jump right into it. So the topic we're having today, I should take a step back. There are two cases which I know, if you've been following our blogs or our podcast recently, have been kind of talked about at length, and that is the Cherneyko decision and the Calmusky decision, both of which kind of dealt with a scenario of did property pass to a kid or a spouse after death, or even in one case during lifetime.
Right.
And in both scenarios, they used Pecore to get there. And we're not going to get into a huge deep dive in either of those cases today, because I know that we've had podcasts and blogs and all sorts of things. If you want to have a deep dive on that, go to there. But the point of the topic today is just both those cases have in common is the use of Pecore. And Pecore, as a case, Supreme Court case from 2007, gets thrown around all the time, almost like you're supposed to know what it means. And it's, of course, Pecore. And people will say, oh, well, they have to, is it a valid gift? Oh, Pecore. And of course, Pecore. And it gets thrown around so much. It gets thrown around both in Calmusky and Cherneyko, and ultimately used by the court in both instances there, that I think in the process, Pecore almost gets muddied up a bit, and you don't quite understand or to take a step back and say, well, when the Supreme Court did Pecore back in 2007, did they actually mean for it to be extended into areas like Cherneyko, like Calmusky, right, or are we kind of going down paths which were never contemplated? And I know when I read, and maybe I'll show my age here, either too old or too young, because I think it's an old meme. But there's a meme that went around a few years ago on the internet from Princess Bride, and it was an image of Inigo Montoya, and it said, "You keep saying that word. I don't think it means what you think it means."
Yeah, so familiar.
So when I was reading both these cases and they kept saying Pecore, that meme popped in my head saying, well, you keep saying Pecore, but that's not Pecore. But what you're trying to expand Pecore to is not Pecore. So you just saying Pecore and screaming Pecore does not get you to the place that I think it should. Right. And that's because, so fundamentally, take us back, Pecore was and is a case which dealt with the joint ownership of property. It was a scenario where the basic question was, in the Supreme Court in that instance, upheld the fact that when an elderly parent places a child on joint ownership for something like a bank account, and also eventually extended to properties, that there's a presumption that that child is holding that asset on a resulting trust for the benefit of the parent's estate when they died, unless they can show that the parent wanted it to pass to them. Joint ownership of property. And in the case, the court goes down a long list of reasons why they're extending that principle. And all of it in summary is basically that the court recognized that in today's world, people are living longer than they were before. And often, kind of as parents get older, kids are added to things like bank accounts and properties as part of their power of attorney duties to help parents manage those assets. And it would be wrong for the court to assume that every time a kid is placed on a joint property, that they meant to have that asset pass to that kid on death. So the kid has to show, no, they actually meant it to come to me. Otherwise, it's the estates. And that makes sense. But that is not Cherneyko or Calmusky, which I think is where maybe we can start our conversation now. So do you want to give us a summary of Cherneyko first? How about?
Sure. Cherneyko involved a woman by the name of Jean Cherneyko. She was 90 years old, and she had no children and lived alone. Actually, I don't think she had any family in Canada, and had one niece in the United States. So Jean had Alzheimer's disease and had been having some cognitive incapacity related issues in her life. And she eventually moved into a long-term care facility. And her friend, Tina, who she'd known for 5 years through discussions with Jean, went to a lawyer, and Jean and Tina went together to the lawyer's office, and Jean had Tina appointed as her power of attorney, both for property and for personal care. And she also had a new will drawn up that left Tina as the sole beneficiary of Jean's estate. 1 week after these changes were made, Tina and Jean went to Jean's bank, and Jean had transferred $250,000 from Jean's bank accounts to Tina. And the PGT eventually got involved in this matter and applied to take over as Jean's guardian and to set aside this gift that was made to Tina. And ultimately, this went to court, and a court determined that this transfer, this inter vivos gift that was made to Tina from Jean was actually a resulting trust, and that Tina failed to rebut the presumption of a resulting trust, and therefore that gift of $250,000 went back to Tina. And this, as you've already mentioned, Stuart, was new, as it was a novel application of Pecore to an inter vivos gift made between two unrelated adults.
Yeah, and that's exactly it, Jennifer. So I said before, Pecore applied to the joint ownership of property between a parent and child, but here we had the scenario where it was actually a full transfer, right? The parent retained no interest in the money. Once it was transferred, it was now solely the kids. So that's a gift. That's not a joint ownership scenario.
Mm-hmm.
Notwithstanding that, the court used Pecore to say, well, wait a second, they actually mean for this to go to you. It's a rebuttable presumption, blah, blah, blah. And here it's a weird scenario because I actually think the court wound up in the right spot in the end.
So do I.
But kind of got there in the incorrect way. And that and kind of the reason why I say that is because there's a long-standing history of jurisprudence on gifting. What is a valid gift? What is not a valid gift? And this was a gift. So if you're going to attack that gift, you attack it on the grounds of gifting. And I have the test here in front of me. So the basic test for is there a valid gift is 1, was there an intention to make a gift on the part of the donor? 2, was there an acceptance of the gift by the donee? And 3, was there a sufficient act of delivery or transfer? So in using that test, you could probably get to the same result here, which is, 1, was there intention to gift? Well, here the answer would probably be no, right? I mean, no, she did not intend to gift because she didn't mean for you to get that property.
Right.
Just so happens that's probably the same test that you'd think about in Pecore. Pecore is, did you mean this property to go to the person when you pass away? So the result's probably going to be the same, but you shouldn't have gone down, probably, I would say, the Pecore road to get there. You could have stayed solely in the gift law kind of lane and got to the same part.
Yep. No, I agree. I think it's an application that, while questionable, right at what we believe is the correct outcome and the right outcome for Jean in this case, given that there were capacity issues and that her intent is hard to determine. But it's a bit murky when we start, as you say, sprinkling Pecore everywhere, and this is a perfect example of that.
Mm-hmm, exactly, right. So I mean, in Pecore, it's more or less the same result in the end, because Pecore's test kind of is part of the test to gift.
Yes.
You're going to get to the same spot in the end probably anyway. But if you go down the wrong road and start applying Pecore to scenarios like this, where it's a pure gift, there's no retention of ownership, you start to wonder, okay, well, in this scenario, you're going to wind up at the same spot. But is there a scenario that you can envision? I can't think of one right now where this kind of gets diluted and diluted to the point where we're now into a completely new realm where this was never applied before. And maybe that's a nice segue to Calmusky, which I would say is exactly that, where the court applied Pecore to a scenario that I would say was never envisioned or applied to before them doing so. Do you want to give us a basic rundown of Calmusky?
Of course. So in Calmusky, it involved a case of a man named Henry who had passed away. And Henry had 2 sons, Randy and Gary. When Henry passed away, the residue of his estate was divided in half. One share went to Randy's children, or one of Randy's children, I should say. And the other portion of the residue went to Henry's nephew. So this might leave you thinking, what about Gary? What does Gary get from his father's estate? Well, Gary was on some joint bank accounts with his father, and it was presumed that those assets would be transferred to Gary by right of survivorship. As well, Gary was also named as the beneficiary of a RIF with his father. And the court applied Pecore to the joint bank accounts, as one does, and found that because they were gratuitous transfers between Henry and Gary, that there was a presumption of a resulting trust. However, this is where things get a little bit different. And the court then decided to take it one step further and apply the principles from Pecore to the RIF as well. And they held that that was applicable in this case. And so Gary, unfortunately, ended up without that beneficiary designation because it was deemed to also be a resulting trust back to Henry's estate.
Mm-hmm. And that is it. That's a new application, right? So we take a step
Yes.
back earlier in the conversation about the context in which Pecore was decided. Supreme Court went at length to describe why they thought there should be this presumptive resulting trust. And the basic principle, as what I said before, was because, well, often kids are added to joint ownership of bank accounts and properties as parents get older to
Yes.
help them maintain those assets. And that's why we need to have this, kind of presumption in place, because otherwise kids who are added to accounts only to help their parents through the, latter years of their life
Right.
could wind up with a scenario where they get a windfall of that account at the
Correct.
back end when the parent never meant that to happen.
Right.
But that is a different scenario, I would say, than a beneficiary designation, because a beneficiary designation, by its definition, means that you don't ever have an interest in that asset during the parent's lifetime.
Right.
It only materializes after death.
Right.
So if that's the case, well, the court's consideration of why we're going to require this presumption of resulting trust to apply to a joint account, well, it doesn't seem to exist in the scenario of a beneficiary designation for something like a life insurance, a RIF, an RSP, whatever you want to go down the road for.
Right.
So then you go, well, wait a second, does that make sense still? Now, I know Calmusky, you can read our blogs and listen to our old podcasts and probably talk to anyone in the profession, is very controversial for that exact reason. And I know a lot of people are saying that it's wrong and it should be overturned, or the law should be clarified for a multitude of reasons. But I think the fundamental question is just, when the Supreme Court wrote Pecore in 2007, did they envision it applying to a scenario like that, where when the fundamental kind of central pillar of why Pecore exists is, well, kids are added to a parent's accounts to help them in their latter years.
That's right.
And that, I don't know. I would say Calmusky doesn't seem to fit that, and that it's, as a result, questionable to say the least, I will say.
That's my take as well. And I also find it interesting, the other issues that come out of Calmusky in terms of testator intention, because in some ways you can read this decision and say, well, Henry's intention to leave Gary as his beneficiary was frustrated by this court decision. And so what is the next step that executors are going to have to take in order to ensure that their beneficiaries end up ultimately receiving those designations that they hold up once they pass away? I know we talk a bit on our blogs about if testators are going to need to execute affidavits or put provisions into their wills in order to guarantee that the transfer of those beneficiary assets, like the RIF, go smoothly.
Yeah, no, exactly. And historically speaking, this is the attacking of beneficiary designations is not a new thing. We have had it since, I've been around and doing this work for about a decade now. But in the past, it was always, well, did they have capacity when they signed it? Were they unduly influenced into signing it? Almost akin to more like a will challenge scenario. When you sign that beneficiary designation, did you actually know what you were doing?
Right.
And those beneficiary designations could be attacked on the same grounds still here, I would say, in Calmusky, right? Someone wanted to challenge that beneficiary designation. Calmusky would say, well, wait a second, I think that he was unduly influenced to sign it. Yes. Don't think he had capacity when he signed it, et cetera, et cetera, et cetera. Yeah. But that's a different scenario than presuming that it's the estate's asset, unless the person named can show evidence of, no, actually, I meant it to go. Why the heck else are you putting someone on a beneficiary designation but to give it to them? There's no function other than that.
No, it's much different than a bank account. There's no use of that really during their lifetime where they would require the assistance of a child or another person.
No, exactly. So Calmusky, Cherneyko, new areas that Pecore is going into, although, back in my meme a second ago, you keep saying that word, I'm not sure it means what you think it means. Just because you scream Pecore at a RIF designation or at a gift doesn't mean Pecore should apply there. And maybe you need to take a step back and think, well, one, what did the court mean when they wrote Pecore? And two, what are the more historical ways that we attack a gift? Was this a valid gift? And beneficiary designations.
Yep, I agree.
All right. Well, good chat.
Very good.
Well, thank you. It's been a pleasure, Jennifer. And
likewise,
hopefully we can podcast again soon. And thank you to our listeners out there. If you want to leave a comment, please comment on our website. And otherwise, thank you for listening and see you soon, hopefully.
Thanks very much, everyone. Take care.